Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. I'm John Roberti, your host for today's episode, and today we're going to be talking about merger trials. Our episode is called How Do You Put the Bricks Together? The Evidence That Makes a Difference in Merger Trials. And so we're going to be talking about key evidence, we're going to be talking about storytelling in mergers, and we're going to be talking about some war stories and fun things that happen. My co-host today is Anora Wang. Anora, welcome.
Hi, John.
Hi, Anora. Anora, why is learning about the evidence used at merger trials interesting, important?
Well, to me, I often hear about merger trials. I certainly see them in the news. But I know that merger trials are actually rare. When they do occur, I think it's high stakes. Learning a little bit of evidence is helpful.
Why are they rare? Why is it that we don't see merger trials every day?
Well, one is because it's high stakes. Parties would settle or find a way out of it, right?
So about 99%, I would think, of all mergers that are reviewed have something happen before they get to a merger trial. All right, well, who's our guest today?
Today we have Katrina Robson. Katie is a partner at the O'Melveny & Myers law firm and a veteran of several merger trials, including the AT&T Time Warner merger trial against the DOJ. Katie is also a vice chair of the Trial Practice Committee at the AB Antitrust Law section.
Great. Well, let's bring in Katie Robson. Katie?
Hi, good morning, John and Nora. It's nice to meet you both. And thank you for bringing me to a recording studio. I love being surrounded by all these musical instruments. This is fabulous. And there's like 4 guitars on the wall. Oh, five guitars on the wall. Isn't that nice?
6. There's another one.
Oh, look at that. I feel more creative already.
So, Katie, let's talk about merger trials to start off with. When you bring a merger trial, who hears it? What's the posture? How does that all work?
Okay. Well, that's a big question. I'll start with a small chunk of it. How's that? So typically there are 2 government agencies. Private plaintiffs can't bring merger actions, by the way, but we'll start with the agencies because that's where most of the action is. 2 agencies bring merger challenges. They have to file a lawsuit to seek an injunction to stop a merger from happening. The 2 agencies are the Federal Trade Commission and the Department of Justice. Anyone who's listening to this is probably well aware of it all, but we'll just cover it real quick. The Federal Trade Commission is typically going to be seeking a preliminary injunction. The Department of Justice will be seeking a preliminary injunction and a permanent injunction. It usually gets collapsed into a single permanent injunction hearing. And because those are injunction proceedings, they are heard by a judge.
So it's very rare. It's in front of a jury?
Well, private plaintiffs could potentially go to a jury if they were going to assert damages. But in that case, rather than being a forward-looking challenge, a challenge that occurs before the merger has even happened, it would be a challenge to a merger that has already been consummated and that they assert has caused some damage.
Right.
Katie, tell us about the storytelling that you do when you put on a merger trial. What are the key types of evidence that you want to put on? What's really important?
I tell no stories, only the truth. No, I get what you're saying. How do you present the company's case? So the company in these circumstances, the most important part of the story is really going to be the evidence of the key executives who made the decision to merge the company. Because those are the folks who need to stand up, look at the judge in the eye and say, this is why we are doing this merger, because we want to be more competitive and because we believe that with this merger we will be able to compete harder and better against the other companies in the industry, causing prices to go down, all for the good of consumers. And those folks really need to stand up and make that statement to the judge. And then that gets backed up by economic evidence. So you want to bring in your economists who can say everything that the executives tell you, we can model it and it's accurate and correct. That is exactly how it will play out in the market. And then you have some third-party evidence that I can talk about as well if you're interested.
Well, let's talk about telling that story. And many times when you want to tell the story through these executives, you find that there have been documents that have been written that may not always be entirely consistent at least on their face, with the story you want to tell. How do you deal with that?
Again, never by any of my executives. What I will say is documents carry with them, there's often missing from documents a lot of context that goes on around them. And so it's important to get a good sense of who wrote the document, why were they writing the document, was this a draft, was this a final, was this something that ever went to the board? How important is this document really in the whole context of the universe of the merger, and making sure you're appropriately placing it, because that changes the weight, if any, that you give to the document.
That's what I would do for the first year of my career, right?
That is what you will spend a lot of time reviewing documents, and you can understand why in a lot of cases people put a lot of weight on documents, because that's how we start our careers, is just by reading documents, often without even talking to witnesses. But one of the things, Anora, you will find as you do start talking to witnesses is you'll have a view of a document. You get in the room with the witness and you say, so I read this in this document, and that means A, B, and C, right? And they look at it and they say, absolutely not. That was actually a typo there. And over here, I didn't know what I was talking about. And that right there, I didn't have the right data. And so once I crunched the right data, I couldn't say that anymore. And by the time you walk out of the room, you may have a completely different view of what that document really means.
So you talked about economists. What do they do?
Things that I don't understand. A lot of math. The economists, you mean in what's their function in a trial?
Yeah.
Okay. So the executives come in, they have a lot of industry background. They really understand how the industry works, and their word carries a lot of weight because typically they've been very successful in the industry in which they operate. So when they say, I can look at these facts and I can see this change and I can tell you this is what will happen on the other end, that experience is golden, right? That's very, very important evidence. But behind that, it's nice to be able to actually put some mathematical modeling that says, okay, here are all of the factors that go into how this market operates. If I change these 3 factors, here's what happens. Oh, and look, prices went down for consumers. Isn't that great? And that modeling then parallels what the executives are telling you and just puts some more, it puts a different lens on explaining what this merger really accomplishes.
What are some of the challenges in putting on an economist? What makes it hard, if anything?
Well, first, I have to understand what they're saying, which is every economist I've ever worked with, by the way, is just absolutely fabulous. I mean, they are so good at sitting down and explaining the very basic principles. But a lot of these principles and theories and models are things that, for instance, have been awarded Nobel Prizes. I mean, these are not simple models. They're very complex. And sometimes you can have computers that run for days just to manage the model. So the most difficult part is actually sitting down and understanding how the model works yourself. And you have to get very deep into it and make sure you understand how all of these factors play together. And no matter how deep you go, trust me, you've not gone deep enough. But you have to spend time doing that. And then you have to come back up from that and get some air and actually think, how do I take what I've just learned, which might have taken me 3 weeks, and boil this down to a 3-hour presentation so that it's simple and easy to follow, very transparent, and I maintain the credibility of my expert because he's not skating over important pieces of his modeling.
Any evidentiary issues ever come up with the economists?
Sure. Well, as I mentioned, because some of these will be preliminary injunction proceedings, the rules of evidence can be looser in that context than, say, other contexts. But economists can have anything from they're using data that didn't get produced, for instance, or that did get produced or didn't get produced with their report. They could have issues related to relying on documents that they shouldn't have relied on because they didn't have sufficient information about them, or they're very clearly hearsay documents. They could have issues around in some cases we talk about folks who actually are just taking an economist and using it as a mouthpiece for third-party documents to try to get hearsay into the record. Again, probably not as much an issue in a preliminary injunction proceeding, but it can happen elsewhere. I mean, obviously none of my experts have had any of these issues, but those are the kinds of issues you would want to think about and avoid as you're preparing your economist for testimony.
And you talked a little bit earlier about third-party documents. Mm-hmm. Why is that important? How does that play in?
Third-party documents or third-party testimony?
Either one.
Okay. So third parties are interesting because often they don't have, particularly if you're talking about a customer, any interest except what's really in the best interest of the customer, which is what the antitrust laws are typically trying to get you to. So if you have a customer who comes in and says, yes, I've looked at what these two companies have said that they want to do. I've looked at their merger. Based on my experience, I'm going to tell you that this is actually good for the industry. I, as a customer, am excited about this because I think this is going to give me a better product at a lower price and more of it available to me. Similarly, if a customer comes in and says, no, I've looked at this, I've looked at what the executives have said, I've looked at the documents, and I'll tell you this, there's nothing here that's good for me. They're actually trying to take away one of my choices in the market. That carries a lot of weight. All of this carries weight to the judge because for the customers, the only thing that they really have in mind is how am I going to get a lower price, which aligns much more closely with the antitrust laws than, say, an executive who comes in and says, hey, my merger is going to be great for my company and help us make lots more money. That could be because they're competing better. Always is in the case of my clients. Always because they're going to be competing better. Or it could be for other reasons that are not as consistent with what the antitrust laws are trying to promote and protect.
What evidentiary issues come up in the context of third-party testimony? So
often you will see the government agencies attempting to bring in third-party testimony through declarations because trials are can be very distracting and time-consuming. And so judges often, so the agencies often will seek to go out and actually get a third party to sign a declaration saying, here's what I think about the merger, and then they want to submit that to the court. There often are battles around whether that can be done because that's a very usual piece of hearsay evidence that in a typical substantive proceeding on the merits where there's going to be a final determination, you're going to say that should be excluded as hearsay. In a preliminary injunction proceeding or other kinds of proceedings, there will often be a battle about whether those declarations can come in or not. And usually how that plays out is because there are issues related to cross-examination. Obviously, you have this declaration. It can't just sit there in the record. The judge will allow the counsel to go out and basically depose, cross-examine the third party, and then that testimony comes in with the declaration. And then, of course, once all of this starts, you can get into declaration battles where because the government agency has gone out and gotten 25 declarations, then the defendants go out and get 25 declarations. So the agency goes out and gets more declarations, and it can become very declaration heavy in some cases.
When you present your story to the judge, what do you think the judge finds to be the most compelling?
Well, that's such a good question. And I wish I had a judge here that I could ask. I would say, look, the most compelling piece of your presentation is always your credibility, and that cuts across the board, right? So that's your currency in a trial, and it should, if you're doing it right, your executive has credibility, your economist has credibility, you have credibility across the board. But if you take that as a given, that everybody's got, just sterling credibility, let me put it this way, if I were a judge, what I would find very moving is having a CEO look me in the eye and say, this is why I'm doing this deal. And knowing and being able to see that what he's telling me is consistent with the other market facts that I've been able to ascertain, and it's consistent with what the economic modeling is telling me, and I've got some customers telling me the same thing, then to me that executive testimony would really be the linchpin that pulls it all together and tells me this is a merger that should go forward.
If there were a government lawyer sitting where you're sitting today, what would the government lawyer say is the most compelling evidence for a judge?
Oh, wow. I'm not sure I'm qualified. So let me start off by saying to all the government lawyers out there, I deeply respect you and everything you do, and I would never want to speak for you. But I think if I were just to put myself in the shoes of a government lawyer, I think the government lawyer would say the converse of what I just said is true. If you are able to undercut the executive's credibility and put something up in front of the executive that really is inconsistent with what he's saying is the rationale, the pro-competitive rationale for his deal, I think for a government lawyer, that would really bring the linchpin. That would be the linchpin of their case, I think. But again, I say that with absolute humility that I have never tried a case on the government side before, and those people, they really know what they're doing. They're very good at their jobs.
Well, Katie, you obviously love doing trial work. What makes antitrust fun for you? And, just coming from my perspective, was antitrust always this fun when you started your career?
Well, so I actually started my career in one of O'Melveny's offices that did not have any antitrust lawyers. I came to antitrust after doing a few general litigation kinds of trials. And what makes it most fun for me is that an antitrust merger trial really brings together all of the things that I do, from reading documents to talking to witnesses to understanding economic evidence and talking to economists. And I get to take all of those things and synthesize it into a single presentation and speak for my client, really defend the reason why they are attempting to do something that they think is going to be good for their company, but good for competition as well. And I have loved all of my clients. They've all been wonderful people. It really has always been a privilege and an honor to represent them and be able to make that presentation for them. So I find that to be, it's like going into battle to defend somebody who you think is in the right. It just, there's nothing like the sense of putting together that story, as John mentioned earlier today, and really feeling like you did a good job for them. You did your absolute best to make sure that they got a fair hearing.
Okay, now we want to find out a little bit more about you, Katie. So,
I've heard about this segment.
well, first, before we get to our next segment is called the Curious Hat. But before we get to the Curious Hat, tell us something surprising or unusual about yourself that we wouldn't know by just meeting you.
Oh, wow. Such a great question. I think the most surprising fact about me that most people don't know by meeting me is that I started life off as a machinist because my dad ran a machine shop. And in what I am sure was a violent violation of child labor laws, taught me to run CNC lathes and mills probably when I was about 11 or 12, once I was high enough to actually reach the keyboard. That's where I began.
Wow.
And that absolutely convinced me, by the way, there's nothing like working in 100-degree weather in a machine shop covered in coolant to convince you that you are going to college and doing something else with your life.
When you were operating the machines, did you ever do any of those things that they tell you not to do before you operate heavy machines?
Well, I was 11 or 12 at the time, John, so my options were limited.
Okay, with that, I think it's time for the Curious Hat.
Okay.
And now it's time for the Curious Hat.
Okay. Curious Hat. Katie will pick a question. I will ask Katie the question, then I get one follow-up question.
I just want to let the audience know these questions have been held in a highly secretive way. I have had no idea what any of the questions were in the hat.
We have an actual hat.
Okay. Katie, you picked a good question.
Oh, good.
Katie, if there were any famous person that you would want to meet, who would that be and why?
Wow. Famous at any point in time. Leonardo da Vinci.
And why?
So, wow, the music's distracting. Sorry, everyone. So I'm actually in the middle of reading Walter Isaacson's book about Leonardo da Vinci. And by in the middle, I mean I started it about 6 months ago before my last set of trials. So I still haven't finished it. But one of the things that was so interesting about him was he asked such interesting questions. Like there was nothing that fell below his observation or that he wasn't willing to ask a question about. One of the examples was he wondered, what does a woodpecker's tongue look like? And I remember reading that in Isaacson's book and thinking to myself, how do you even think of that question? Like, what causes you to actually pay enough attention to be watching a woodpecker and to be thinking to yourself, well, I wonder what his tongue must look like. And that is just fascinating to me. I would love to meet someone whose mind works like that and better understand how that person comes to the world and interacts with it.
But do you think Leonardo da Vinci was cool? Or, I mean, do we know anything about whether he would make a nice conversation?
Oh, I think if he can ask questions like that, absolutely. I think a conversation with Leonardo da Vinci would be very interesting.
So then I get to ask the follow-up question, which is, okay.
There's a follow-up. Now, that was not part of the deal.
So, okay, same question. So what famous person, anytime, any place, would you want to avoid if you saw them across the room?
Wow.
some name calling time.
I know, no kidding, right?
Yeah.
I have to call someone out.
Yeah.
Now I need to go way back in history.
So wait.
To be safe.
You have to call out some person who's been famous since the dawn of time. You can call out a dead person. That's really okay.
Okay. I think I would cross the room and avoid meeting Catherine de Medici.
And why is that?
She did not seem to have a very positive view of the world.
I get that. Yeah.
Okay. Katie, thank you for joining us.
Oh, it was my pleasure. Thank you for having me.
That will do it for today's show. We will be back next week with our next episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by the ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out to us at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.